All rise. The Court of Appeal is before the 4th District in the state of Florida is now in session. The Honorable Harvey L. J., Judge presiding. All persons have business before this court draw near. Give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to the Duval County Courthouse. We are the 5th District Court of Appeal, traveling to Jacksonville today. Thank you for being here. Thank you for being a part of everything. We're sorry for being a few minutes late, but the catacombs behind the courtroom got the best of us. I have the privilege of being here today with two of my fine colleagues who started at the same time I did in January of 2023 at the 5th DCA. Judge Kilbane, to my right, who has done just about everything in the court system at one time or another, is extraordinarily qualified for all the reasons represented in her bio, but very fortunate to have her on the court and fortunate to have her with us today. And to my left, Judge McIver, who I believe has held every important job in Tallahassee. Again, you can see those wonderful things on his biography on the 5th District website, including the fact that he was the chief judge of all the administrative law judges for the state of Florida. So that's, boy, is that impressive. I'm Harvey J. I will be the presiding judge today. This is a court of law, so all the things that would normally apply to a court of law apply today. We will treat you with respect and dignity, and I know you will do the same for the panel. We have 3 cases on the docket. The plan is right now to take a break after the second case, so we will move through the first and second cases and then take a short break, probably about 10 minutes, and come back for the third. If there is nothing further for the court, I will say one thing, and I hear the chief say this all the time. If you do have phones or electronic devices that are not silenced, that would be appreciated. One other thing that would also be appreciated by the panel, if you would be kind enough, if there is a reason you need to leave the courtroom, to wait after we have completed the case. That can be distracting, as you can imagine, for not only the oralists but the panel, to have people coming in and out of the courtroom while we're listening to arguments. So thank you for being mindful of those things, and without further ado, our first case on the docket today is Michael Orlando versus State of Florida, case number 2024-1679. Counsel for the appellant.
Good morning. I'm Elizabeth Harris, and I'm here on behalf of Mr. Orlando. And one of the principal questions we have this morning is whether the judge properly gave the stealth instruction. As you know, Mr. Orlando was convicted of burglary with the intent to commit a crime therein. And the judge gave the stealth instruction on the basis that Mr. Orlando employed a neighbor to knock on the door, put himself in a position where he could not be seen when the door was opened. I think that's a direct quote from the charge conference. So what I would suggest to you that what happened here is the judge confused stealth with false pretense. And I would suggest that they are very different things. So when you think of stealth, the statute doesn't define stealth. The case law tells us it's clandestine, sly, and when I think of stealth, I think of the idea of a stealth bomber. You know, the plane comes in with the intention to be undetected, do its job and get out. You would think of perhaps the stealth police cars that drive up and down the highway that are intended not to be detected.
And thank you for all that, Ms. Harris. Does not stealth also bring to mind being surreptitious or not? I mean, help us understand that.
Well, I think when you look at the case law employs dictionary definitions, and surreptitious is one of those. But when you look at the idea of trickery or false pretense, this is not a situation where, or it is rather a situation where perhaps that you might equate it to a situation where someone knocks on the door and uses someone else's name. Knocks on the door, I'm knocking at the door and I say, it's Mike. Well, it's clearly not Mike, I'm Elizabeth. Or I claim that I've been injured. I need to use your phone, I've been hurt. I need to use your telephone, my car broke down. And I think that's analogous to what we have here, as opposed to the case law that talks about entering in the dark of night, entering with the intention to not be discovered. And when you look at the video here, there's a couple of really important things. First, you can tell it's absolutely broad daylight. There's not a cloud in the sky that day.
You said entering in a way not to be discovered. Wasn't that the appearance that your client gave here, that he did not want to be discovered?
Well, I think the case law, and I would suggest to you that's where the trickery comes in, the idea of trickery. It's with the not to be discovered, and there's a difference. It goes to the consent to open the door, not the intent to commit a crime therein. Because when you look at those cases, they are definitely talking about entering to avoid discovery, as opposed to the cases that talk about trickery, where you are tricking the person to open the door, and then you say, well, they let me in. That's a different scenario here, because when we look at the facts here, the neighbor clearly can identify him. And the testimony talks about how he has a prominent neck tattoo that's not covered. As I was saying, when you look at the video, there's cars passing by. So he's not intending to avoid discovery, and those equate to the cases on stealth. He's plainly visible, it's broad daylight, he speaks to someone.
In your opinion, would any of those facts, the neighbor, the car driving by, would any of that matter in that he is not using stealth to try and conceal the entirety of the crime? He's using, as you phrase it, trickery to be able to then commit the ostensible crime, but he's not using it to avoid the crime being discovered itself, because he's going to confront the victim.
If I'm understanding your question, and I don't mean to be dense, but I think I understand your question. You're saying that the difference here is, as to the prima facie, the inference, when with the idea of the stealth, it goes to the intent to commit the crime therein, not the consent to enter. And I think that's what you're...
Or to conceal the crime, to conceal the entirety of the crime, not just the, I'm going to hide for a minute so that I can then commit the crime. Stealth is, I don't want this crime to be discovered.
Exactly, the case law talks about discovery. Well, golly, I must not have had that touched on properly. That's exactly what the case law talks about, avoiding discovery. And all of those cases are factually so very different than ours. This is all in broad daylight. He can be seen, he can be identified. I think the cases are much more like the person who knocks on the door and says, you know, my car broke down, I need to use your phone, and then they enter and commit a crime therein. I think this case is much more similar to that, as opposed to the cases where, someone's sneaking in the back door in the dead of night. They have a mask on. Those are the cases that are found to be stealth. And here, it's really important that it was harmful, it's significant, because the state repeatedly references that the inference, the prima facie finding the intent to commit a crime by his entry the way he entered. So I think that it is definitely a situation where the error goes to the foundation of this case and it warrants reversal. Coupled to that with what we have.
If there were another express offense that he had committed, the violation of the pretrial release order, would it still require reversal, or would it then be harmless?
So that's exactly where I was headed. I think the idea that the state argues that there was an intent to commit a battery, or if there was not intent to commit a battery, he was committing the violation of the domestic violence injunction and the pretrial release conditions. And we don't need to talk about the DV injunction because that was JOA by the judge. So with respect to the violation of I think it's significant here, the state, and I do believe the state completely misunderstands Gaskins and the case cited in Gaskins out of Connecticut, because Gaskins talks about the escape being completed once he's out of custody, once he steps out of custody. And I would argue that is exactly here because we have a parameter of when this crime occurs. Once he's within 500 feet of the victim, and I think it was 100 feet of the house, I don't recall, it's one or the other.
That would seem to me that it would speak to his ability to complete a crime that's already been completed, the impossibility of then completing something that's already done. But how would it then speak to intent? Impossibility is not a defense to intent. Unless he knows it's impossible. Would your argument be that the jury was precluded from believing that he was such a sophisticated actor that he knew that this crime was already completed and he couldn't therefore complete it?
I think that, I'm not sure I'm understanding your question, and I apologize. The Gaskins talks about legal impossibility, and I think here, and maybe this answers your question, when the intent to violate that was already formed prior to entering the house, and burglary, particularly with the instruction, that there was an intent to commit a crime inside of it. So his intent was already formed before he got there. So that idea that he was going to commit, and when I kind of bantered this idea around, was his intent to get even more of a violation by entering? I mean, he had already done that. He'd already completed that. When you entered that 500-foot radius, and I apologize if I'm incorrect, if it's 500 or 100, whatever the parameter was of the offense, and I do think it's 500. Once he entered that, I think that's done. He violated that. How does he have the intent to enter with the intent to do that crime? He'd already done it. And, the state argues that he was aware of the conditions of the bond release, so once he's done that, it seems a legal impossibility. It seems legally illogical that he would intend to commit the crime that he already did once he...
What about the battery, purported battery?
So, I think where it becomes problematic is the jury's hearing all of this. I do think it's problematic that they hear because the state is talking about, with every step that he approached the house, he had an intent to commit a crime. They're hearing all of this. So when we have an instruction that allows them to say there's a prima facie intent to commit the crime, and we know that the crime that the state is arguing, one of the crimes they're arguing, setting aside the DV injunction, was the violation of the pretrial release conditions, we're left with an unreliable verdict. And there's little evidence of a battery. And I don't know that this court can say that, given the instruction and the argument that centers heavily on the stealth and centers on this ongoing crime that was occurring, that we can be certain that the conviction was not based on these errors, as opposed to the jury finding that in fact a battery occurred.
If the jury did find that, then that argument you just made evaporates, correct?
I don't think that we can arrive at that conclusion given the layer of errors that have occurred here. We've got an improper instruction, and we got the jury arguing a crime as a basis to find him guilty. The crime therein being the violation of the pretrial conditions. I don't think, aside from the fact that I think the court erred in trying the DV injunction violation of that and the severance issue that is the first of the issues I've raised. I think the jury now has heard. As a matter of fact, I mean, they hear he's in custody, they hear how long he's in custody, he hears there's prior domestic violence.
And the severance issue, and I believe that was your first issue on appeal, the standard for that, though, is abuse of discretion.
Yes, sir, it is.
And just so we all understand, what would need to be established in order for us to find that there was an error, the court abused its discretion related to that?
One of the things the judge says is, I don't know how they can prove this crime without these other offenses being charged with them. Again, the jury hears about the DV injunction, shouldn't have. Judge J. lays out, so we know that that's happened. But if it comes with the premise that it's an ongoing offense, because that's what they use, we get into a sort of a cycle here. They're using that offense to prove their offense when that offense was completed before he entered the burglary.
And the cases that I've read on that issue talk about the events being inextricably intertwined. And it seems to this judge in this case that these three events are inextricably intertwined. Are they not?
Well, I think to the extent that when you are overcoming or infringing on the presumption of innocence, and here we're talking about prior bad acts, because remember, they're saying he entered to commit a battery, and they're hearing that he previously did a battery. And we don't have a finding of Williams rule or any of those things. We don't have that happening here. So I think it is overcoming the presumption of innocence, because the state has this sort of what I might characterize as like throw a couple things at the jury and see if they can find it, and it becomes, as I was saying, cyclical. He previously committed a battery. The evidence of the battery here, and when you listen to the video, I think it helps us get a sense of what was going on in there. It's very, very short and very, very quick. But he's saying, I'm sorry, I'm not touching you, I'm sorry, I want to talk to you. I don't know that the domestic violence that comes in aids the finding of the intent to commit the battery here, absent what you can see on the video and the testimony. Because the testimony is, in and of itself, doesn't establish a battery.
Ms. Harris, I did not ask you on the front end about rebuttal. I'm going to ask you now. Would you like to reserve some time for rebuttal?
Actually, I'd like to reserve the rest if I could.
That would be fine. Thank you.
Good morning, may it please the court. My name is Tabitha Mills, and I represent the state of Florida appellee in today's case. I will address the issues on appeal as raised in appellant's argument with the first question, principal question of stealth. It is the state's position that the trial court properly gave the stealth instruction, as there was evidence to support giving the instruction. Of importance here is the Reed case and the definition of stealth, as appellant talked about a little bit during her argument. Essentially that stealth is done surreptitiously, furtively, and then there's that word sly. And I think that word sly is what really goes at the heart of this case here. Sly meaning it being done in a cunning or deceitful nature, which the state would argue is exactly the facts that we have here. We have somebody who knew he was not supposed to go and have contact with the victim in this case and employed a third party through deception, lied to that third party in order to get him to knock on the victim's front door. The state's position would be that if without that deceptive nature, without the appellant telling the neighbor that this was his girlfriend, who he was going to deliver flowers to, and if that neighbor knew of the actual circumstances, would have never knocked on the door, so would have never gotten to the victim. And so I think, and then even without the stealth instruction, the state does believe that there's a prima facie case of intent to commit an offense there and for the purposes of burglary, which would go towards the JOA argument as well. Here we have evidence of, we have the stealth evidence, we also have evidence of intent to commit a battery. There is testimony from the neighbor and the victim, the only lay testimony in this case, that the appellant ran into, and we see it on the video as well, the appellant ran into the home, had his arms out, was attempting to touch her. There was testimony of maybe attempting to hug her, which the state would posit is still a battery as long as it's an unwanted touching, which the victim testified that she did not want him there. So I think that the jury had enough for intent to commit a battery. Further going to the violation, I'll focus on the pretrial release conditions, the violation of pretrial release conditions. While appellant focuses on 500 feet away from the residence, as charged in the information and also in State's Exhibit 5, the bond conditions themselves, there are several ways to violate the pretrial release conditions. One of them is going within 500 feet of the residence. However, if the jury concluded or came to an inference that this was not her residence for whatever reason, there is also a no contact order, so a no direct contact, a no indirect contact, violent contact, or contact through a third party. So the state would posit that this is another way that the appellant can violate the pretrial release condition. So just because he is within the 499 feet, whether or not this court concludes that that is a completed.
What about their argument that it's unfair to his presumption of innocence to roll all three of these events together? And as you just heard Ms. Harris say, you have this previous battery being superimposed on this event, and so did that not potentially taint this jury?
So the state would argue that if there was any error in denying the motion to sever, that it was harmless because the evidence of the other crime still would have been relevant to prove the intent argument. Specifically in terms of the prior battery, which I believe is defense's argument was the basis for the pretrial release conditions, the domestic violence case. My recollection of the record is that that was very, very briefly discussed and did not go into details. The defense did stipulate at trial to the fact that a domestic violence arrest occurred on May the 25th, I believe it was, of 2019, which started these cases going. And that was, the state would argue that there wasn't much else that was testified to in terms that would add on top of that. And I may be incorrect in my recollection of the record, but I don't believe that I don't believe that she used the word battery. I believe that she said there was a domestic violence incident. And the defendant was arrested for that, and as a result of that, she was made aware of bond conditions, and as a result of that, she obtained a restraining order against him. That seems to go in line with the stipulation, even if she hadn't testified to those facts. That seems like that is all covered in the stipulation, so I don't see the stacking of using this battery, or using that previous battery to then try and prove intent to commit this battery here, because I don't think that those facts are fleshed out much. So the state's position would be that that was harmless, if any error in denying the motion to sever, that it was harmless error.
One more time, could you just run through the total sum of evidence that you say speaks to the idea that there was intent to commit a battery?
The intent to commit a battery, the victim testified and the neighbor testified that he bum rushed in and he had his arms extended towards her. I also think that the surveillance video in which the defendant is saying, I'm not touching you, goes to her belief that she thought that he was touching her. I don't think that he would say that if she wasn't doing anything to make it seem like she actually believed that he was trying to touch her. So I think you can use his words as well as those two testimony. And then you have the neighbor who was aware of the victim. It says that he lived 3 doors down or 3 homes down. But other than that, I had no idea what was going on in this case. Knocked on her door and then testified that he thought that the defendant was trying to touch the victim. Whether it was a hug or whether it wasn't a hug, whether it was something more aggressive, even if it was a hug, that's an unwanted touching.
Where's the line between approaching someone with your arms out as an invitation to embrace versus I'm going to embrace you against your will?
I think the facts here all go towards that it was an unwanted touching, and I think the statute makes it clear that if the victim does not want to be touched, then that's it. It's not.
That misses my question. What's the difference between someone who is approaching with their arms extended, come back to me, hug me, whatever, versus someone who is then going to make the decision to embrace someone against their will?
And if I understand your question correctly, is this maybe talking in a sense of somebody standing still with their arms out, no longer approaching the victim? Because I think that if you are continuing to make those steps with your arms out to the point where you're not stopping, and as long as the victim does not want that touch, that intentional touch, to touch them, then I think that would separate whether it's an invitation or whether it's a battery. And then I feel like maybe I touched on everything. I just wanted to go very quickly. The defense brought up Gaskins really quick, and there was some discussion very briefly of Gaskins in the, I believe it was at the charge conference is when it came up at the trial, and the state relied on Wallace, the case, appellate case from Connecticut, which is cited in Gaskins just to distinguish the ongoing versus the completed crime. The state's position in terms of that is that, again, there's multiple ways that you can violate the pretrial release conditions, and so as long as there are other ways to violate that no contact order, that direct contact.
I don't think the argument is about whether he could violate it or not. The argument is about whether or not he had an intent, a continuing intent to violate it. And I think opposing counsel's argument is that he couldn't intend to violate it if he knew he had already violated it. Can you speak to that issue? When he entered into the building, how could he possibly be intending to violate that pretrial release if it was already violated?
Well, I think he's intending to violate it by having direct contact with her, or by having indirect contact with her, or by having violent or physical contact with her. I think all of those are ways that he could have intended to continue violating the domestic or the pretrial release conditions, the bond conditions. And I think that goes to the intent in terms of violating that bond order. I wanted to address the issues as raised during the defense's argument. Is there any other questions that the court would have for me on any of the issues? Well, if there are no other questions, then the state would ask that this court affirm the judgment of sentence in all respects. Thank you.
So I think I would pick up with the definition of slide. So the state is arguing that it's cunning or deceitful nature. And I won't dispute if that's a dictionary definition or not, but I would note this. That is very similar, and particularly in this case, recall the judge says she wouldn't have opened the door had she known. And I think the state argues that in closing as well. In closing, the state argues that he employed the neighbor because the jury can infer the victim would not have answered the door if she knew he was out there. And I would suggest to you that goes to false pretense. It doesn't go to slide. Go ahead.
Let me ask you this. Slide certainly is a descriptor of an element or a factor of stealth. Perhaps not a synonym for stealth. If we were to adopt the state's broad reading of stealth to include anything that includes an element of slyness, can you think of things, and I hate to put you on the spot about this, but can you think of things that would then come into the purview of stealth, which we would think are obviously outside of bounds?
Well, I think maybe the example I've given you all along, where you're knocking on the door saying, I think there's even a case where the defendant knocks on the door and he's claiming to have a toothache, and they said that's trickery. That's not, that's to gain access. That goes to consent. Because remember, consent's a defense to burglary, right? And so that false pretense, and I think even the state is arguing this, she wouldn't have opened the door. Well, that's not stealth. Stealth goes to the intent to commit the crime therein. They're two different parts, right? Burglary is a defense to burglary would be, Judge J let me in. Now, but he didn't know it was me, right? He didn't know it was me, but he let me in. That would be my defense. But that's a false pretense. That goes to consent. Not that I did everything possible to avoid it being discovered. And I think here, when you look at some of the cases, they talk about the individual was bound to attract attention. And here there's no way Mr. Orlando was not bound to attract attention. He's pacing up and down the street. There's cars driving by, broad daylight. He employs someone who can readily identify him. He's not masked, he's not covered, he's not even attempting to conceal a very prominent identifying marker, the tattoo he has on his neck. So I think when we look at sly, we can't equate that to what the case law is telling us, that you're acting in a way to avoid attention, to avoid discovery. And we have the state over and over saying things like that. That he put together a scheme. Well, his scheme was to gain, not to commit the crime therein. It was to have, the evidence would suggest it was to have her open the door. That's the false pretense, not stealth.
And counsel, and I don't mean to cut you off, I just want to clarify something. So a lot of your argument is really centered on the sufficiency of evidence going towards stealth. But that was not the argument made below, was it?
Well, the defense raises Reed and brings Reed to the court and says, here's this case. You can't give stealth based on the Reed case. And the judge says, I think I'm going to give it because he employed the neighbor, put himself in a position where he could not be seen. So I think it's preserved. The judge, the idea of discovery was presented to the judge, and the judge says, based on Reed, what I would purport to be a misreading of Reed, I'm going to give the instruction. So I think the state's position that it wasn't preserved is, I would disagree with that. I think it's amply preserved.
And to go back to your layers analogy, if that layer were to fall, if we were to find it wasn't preserved, how does that impact your argument?
I think you asked if it's not preserved, does that eliminate and no, I think it goes to a fundamental error, absolutely, because the case law talks about having an instruction. This goes to an element of the offense. So the idea of fundamental error is very much present here when you're giving an improper instruction. And I believe I cited cases in my brief that deal with that. I don't think this court can find that to not be fundamental error when it goes to the very element. And it allows the jury, in the absence of what I would purport is the absence of evidence of battery, that now they've got an instruction that, and over the state argues, he put this scheme, that's intent to commit a crime. They argue that to the jury over and over throughout their closing. He's hiding around the corner knowing that he isn't supposed to be there. They emphasize this stealth, and I would suggest to you improperly. I only have 20 seconds left, so if you have a question for me, I'll use those 20 seconds for that purpose. Thank you.
Thank you.
Have a wonderful morning.
Well presented on both sides.